Greetings and welcome to Law of Evidence Relating to the Family from American Jurisprudence. Well, let's get right down to it because here's a footnote from the last one. This is not yours truly, the tribe. However, let me bring this up here. Yeah, it's just a serendipitous notation there. Not to be confused with the subject of the matter here is relating to the family. Starting with Part A with marriage, and Section 1 here with the existence and validity. Starting with Section 214, ceremonial marriage. Let's jump over here to the chat and see if anyone has received notifications. It seems like that is the case. Welcome, audit them. Let's get down to it. The law presumes that any marriage which has been solemnized in accordance with the laws of the jurisdiction where the ceremony is performed is valid. This presumption may shift the burden of persuasion as well as the burden of production. Courts categorize this presumption as particularly strong, some going so far as to say that it can be overcome only by clear and convincing evidence. So we're talking about way beyond reasonable doubt or preponderance of evidence or probability. We want to see clear and convincing evidence to the contrary. Moreover, where there's proof of a marriage ceremony, the law will presume the capacity of the parties and all essentials to the validity of the marriage. So what we have here is that the laws presumes any marriage that has been solemnized in accordance with the laws of the jurisdiction where the ceremony is performed is valid. And that's footnote 40. Dennis versus Railroad Retirement Board. Oh boy. I'll tell you what, from what I understand, you get a pretty healthy retirement for your spouse from the railroad. So that I could see being a very lucrative case and worth pursuing. But that's just what I've heard because, as you all know, that this broadcast is intended for the educational, entertainment purposes of the YouTube channel only, not to be used, presumed, misused, or misconstrued for anything legal, lawful, personal, private, financial, tax, or otherwise, so please don't use this at home. Let's continue. So we see here a very strong presumption here in law that is affected by the jurisdiction of where the ceremony is performed. It makes it valid with that presumption pretty much anywhere, it seems. And at least the presumption is applied anywhere because it will shift the burden not just of persuasion but as well of production. So if someone is claiming that a marriage is not valid, the presumption that a marriage exists will shift that burden of persuasion and production to the one claiming that it doesn't exist. The presumption in favor of the validity of a marriage increases with time. Wow. So it ripens, huh? It is a logical extension of these presumptions that the marital relationship, once entered into, is presumed to continue until its dissolution by death, annulment, or divorce. And we have here the annotation, rights in descendants' estate as between lawful and putative spouses. Putative. All right, well, you know what that means. I can't tell you what putative means, but our good friend Black surely can. So let's find out what it means. Take a quick sidestep here. And as you know, this is a scanned document. It takes quite a while to get there. Oh, we stop on estoppel, a bar that prevents one from asserting a claim or right that contradicts what one has said. All right, eyes here. It's catching up with us. It's out of my control right here until we get. It's getting there. the L's. All right, now it's caught up with us a little bit. All right. So this isn't punitive, it's putative, if I'm saying it correctly. Again, it's a word I don't know. We're going to go with fasterness. All right, here we go. We're getting there now. We're in the P's. But it's at the end of the P, so let's do a big skip here, and hope we don't go too far. A lot of good words in this dictionary, though. The nice thing about flipping through the pages of a real one is that you can stop more easily on things that catch your eyes serendipitously. All right. The R's. Jeez. All right. There we go. PUs. There's punitive, but this is putative. There we go. Wow. Okay. Putative, reputed, believed, supposed. And putative, there's putative damages just as there are punitive damages, and that's under damages, which would be interesting. There's putative father. I did say it correctly, thank goodness. And putative father registry in family law, an official roster in which an unwed father may claim possible paternity of a child for purposes of receiving notice of a prospective adoption of the child. Wow. Children out of wedlock and adoption. Receiving notice. Wow, interesting here. Putative Fathers Act. And then there's putative marriage, putative matrimony, putative spouse. Great. So this doesn't help too much because we have to get, it just means believed, supposed from the 15th century. So the supposed father, supposed marriage. Interesting here, though, because we got to find out now putative marriage. Hopefully this will catch up with us. All right, here we go. Almost there. Oops, we passed it. What that? What am I doing here? It's gone the wrong way. There we go. Marital. It was the, geez, remember the name again. Putative spouses. But we were getting putative marriage. Oops. Hang on a second. No, this is, all right. Give me a second here. R's. Passed all the R's, didn't it? Jeez. There it is. R, nope. R, there it is. Marriage. We just want the straight goodness here. All right, so is putative marriage. Here we go. Putative, finally. Putative marriage. A marriage in which either the husband or the wife believes in good faith that the two are married, but for some technical reason, they are not formally married, as when the ceremonial official was not authorized to perform a marriage. A putative marriage is typically treated as valid to protect the innocent spouse. The concept of a putative marriage was adopted from the Napoleonic Code in those states having a civil law tradition, such as California, Louisiana, and Texas. This type of marriage is also recognized in the Uniform Marriage and Divorce Act. The legal rule by which putative marriage exists is sometimes referred to as the putative spouse doctrine, also termed putative matrimony. All right, we'll edit out that interlude there before we get to the putative marriage definition. Let's get back to the main topic. So, rights and descendants estates as between lawful and putative spouses. Interesting here. All right, let's jump over here to the chat here briefly, since you stuck along with that digression. Bouvier's, yeah, but Bouvier's is separated into a volume for each letter. It'd take just as long and be just as annoying because the way it's typeset. It's having a bill of equity complaint on record. Not quite sure. A good or bad thing. Not quite sure. It depends who you would be talking about, too. But perhaps we can clarify later as we continue. So here's a comment note. Let me get back to this here. There we go. The comment notes the effect of presumption as evidence. The effect of presumption as evidence or upon burden of proof, where controverting evidence is introduced, as in the American Law Review there. Then there's mental capacity to marry, and the validity of solemnized marriage as affected by absence of license required by statute, and what constitutes intoxication sufficient to warrant annulment of marriage. Divorce decree as res judicata or estoppel as to previous marital status. Wow. Against or in favor of third persons. Then there's practice references with the validity of marriage from the AmJur proof of facts. And let's see here. Only the existence of a marriage is established. Oh no, sorry. Once the existence of a marriage is established, a strong, though reputable, presumption arises that such marriage is valid. A marriage, in fact, is presumed valid. So we have here, once a marriage is shown to have been ceremonially entered into, it is presumed legal and valid. The burden of producing evidence to rebut the presumption of validity attaching to an individual's ceremonial marriage rested on the parties attacking it. And that burden of proof could be met only by producing proof so cogent and conclusive as fairly to preclude any other result. So that's clear and convincing evidence. Recognition by form state of marriage, which, although invalid where contracted, would have been valid if contracted within the form state. Let's see here. All right, that's it for that section. We're on to section 215, common law marriage, cohabitation, and repute. This should be exciting. But before we get to that, let's jump over here to the chat and catch up. And I believe we're all caught up. Everyone on the edge of their seat, let's go. When a couple cohabits together and are reputedly husband and wife, law has traditionally recognized a presumption that they are in fact married. And this presumption is applied whether the underlying marriage was ceremonial or contracted pursuant to common law. The rule allowing a finding of marriage based on cohabitation and reputation alone, moreover, is one of necessity to be applied only where other proof is unavailable. Wow. So the reputation, right? Finding a marriage based on cohabitation and reputation alone is one of necessity to be applied only where other proof is unavailable. So seems like, again, you have that full presumption, in fact, even in a common law marriage or cohabitation, and when you are reputedly or by reputation the husband and wife. Both cohabitation and reputation must be shown in order to raise the presumption of marriage. Cohabitation and reputation are often required to be constant and continuous. Proof of reputation must also be general and not confined to a few persons in the immediate neighborhood. So, looks like we have a few bars to get over here. Must be shown, the cohabitation and reputation, constant and continuous, and it must be general, not confined to the neighborhood. Where it has it in the hood. All right, the presumption may be said to gain strength as measured by the test of probability in proportion to the length of time during which the cohabitation and reputation of marriage have continued. But each case is decided on its own facts. In a divorce action, some courts, reasoning that the plaintiff can testify that a marriage had taken place, have held that the presumption should therefore be inapplicable. Parties to a common law marriage are presumed to have had the requisite mental capacity to contract marriage. So as we see, marriage is a contract according to footnote 56. Let's see here. State of Hendrickson. Let's look at the rest of these footnotes here. Cohabitation and reputation raise fair presumption that common law marital relationship exists. Cohabitation does not create marriage, but merely raises presumption that marriage exists, shifting the burden of proof and production, it seems, in these cases. Rebuttable presumption of marriage, where constant cohabitation and general reputation of marriage coexist. There must be at least evidence of cohabitation and reputation of marriage to give rise to the presumption of common law marriage. And then we have some annotations here with American Law Review and proof of facts. Let's see here. Cohabitation cannot be established on basis of a 2-day visit to the District of Columbia. Fact, that party stayed in Pennsylvania 2 nights, at most, was not enough to establish presumption of marriage based on cohabitation and reputation. 2-night stand, huh? Let's see here. Even though both parties divorced their former spouses and cohabitated for about 18 years and represented themselves as husband and wife, the court found that no marriage existed because they argued over whether to get married and were still married to both former spouses during much of their cohabitation. They argued. Evidence of cohabitation and reputation do not raise presumption of marriage where parties know their relationship is Meretricious. Meretricious. Evidence of cohabitation and reputation do not raise presumption of marriage where parties know their relationship is meretricious. And this word here is a great word to pronounce right. Does it have the meretricious? Is it based on merit or not? Seems like it's not, because it would be meretricious. All right, so let's look at it in Black's Law. Because we're back to terminology. Luckily, we're close enough to the M's where we should find it quick enough. Let's check. Yes, we're there. All right. Oops, Mary, we passed it. Meretricious. There we go. Meretricious. It's easier to say than I thought. Meretricious. 17th century. An adjective involving prostitution. Oh, gosh. Okay. Well, that's a nice euphemism. Meretricious encounter. 2. Of a romantic relationship involving either unlawful sexual connection or lack of capacity on the part of one party. Geez. A meretricious marriage. 3. Superficially attractive, but fake nonetheless. Alluring by false show. Meretricious advertising claims. There's the meretricious relationship, which is archaic. A stable, marriage-like relationship in which the parties cohabit, knowing that a lawful marriage between them does not exist. All right, so now we have a great word here, meretricious. And let's get back to the subject. So, now reading that in context. Oops, wrong one there. There we go. All right. Evidence of cohabitation and reputation do not raise presumption of marriage, where parties know their relationship is meretricious. Court's authority to award temporary alimony or suit money in action for divorce, separate maintenance, or alimony where the existence of a valid marriage is contested. See American Law Review. And then we have that nice estate of Hendrickson in Kansas. Now we're on to section 216, rebutting presumption and shifting burdens. And as we saw before, production and persuasion dealing with these cases in a lot of cases. All right, Bill Thomas, I would not know if I was insulted or complimented if I was called meretricious. Now I know. And it's a very, I guess you could say, a polite way of insulting someone. All right, I digress. Let's continue. Once a presumption of marriage has been created by proof of cohabitation and repute, the burden of persuasion shifts to the adverse party to disprove its existence by clear evidence. That's a very quick one there. Once prima facie case of common law marriage has been proved, thereby raising the presumption from proof of general repute and cohabitation, burden of proving illegality of marriage shifts to those who challenge it. And presumption of marriage, once established, must be overcome by clear and positive evidence. And where persons live and cohabit as husband and wife, and are reputed to be such, a presumption arises that they have been legally married, and this presumption, especially in a case involving legitimacy, can be rebutted only by cogent and satisfactory evidence. And cohabitation and reputation are only the mere circumstances from which a marriage may be presumed and rebutted by other facts and circumstances. All right, now we're down to Section 17, cohabitation without marriage. And let's jump over to the chat and see if there's any new information here. Looks like we're all caught up. Let us continue. The law presumes that cohabitation that was illicit or meretricious at its outset remained so. So if you started it out with the prostitution, etc., something meretricious, it remains so. The presumption that a relationship that begins as meretricious continues as such depends on two related things: the knowledge of the parties and the intent of the parties. Nice. A relationship which began as non-marital cohabitation may, and often does, ripen into marriage. The couple may exchange vows in a formal wedding ceremony, or they may contract a common law marriage. Because the relationship began as a non-marital cohabitation, however, the law presumes that the relationship remained non-marital. Thus, the party seeking to prove that the couple did, at some point, marry each other has at least the initial burden to produce evidence to overcome the presumption. Nice. A relationship illicit at its inception does not ripen into common law marriage once the impediment to marriage is removed. The existence of a marriage from cohabitation. Reputations under AmJur marriage, section 132. And now we're on to part 2, validity of second marriage, section 218, generally. Let's jump over here back to the chat. Despite rumors, Ernie and Bert could not be found common law married under Muppet law. Indeed, I think if we get down to some of the older versions of Black's Law, you'd find that husband and wife are slightly differently defined than 9th edition, but I digress. Let us continue. The law presumes that a second marriage, like the first, is valid, and that a prior marriage of one of the parties ended in death or divorce. A key factor in raising the presumption will be evidence that the parties acted in good faith and intended to marry. Once it is proven that a marriage exists, the law presumes that the marriage is valid and lawful and continues without termination. The presumption of the validity of a marriage, on the other hand, supports the inference that the second marriage was valid and that the first marriage, therefore, ended prior to the second marriage. So here's the presumption of validity of a marriage, right? Is one hand, it supports the inference that the second marriage was valid, right? The inference that this presumed fact, the second marriage is valid, and the first marriage, the basic fact, therefore ended prior to the second marriage. When confronting this inconsistency, the law generally gives the latter presumption precedence, presuming the validity of the second marriage. Among the policy considerations supporting this presumption is the need to protect family stability. Wow. The need to protect family stability, particularly where invalidating the second marriage would render children born of that marriage illegitimate. But the presumption is also occasionally indulged in, even though children are not involved. Another important reason for the presumption is the need to protect the financial interest of an innocent spouse who is unaware of the other spouse's prior marriage or doubts as to its dissolution. Wow. The party seeking to invoke the presumption must first prove the basic fact that there was an apparently valid second marriage. Okay, so that's the basic fact. There was a valid second marriage. That has to be proven. So if you want to invoke the presumption, you must first prove the basic fact What is that basic fact? The second marriage was valid. So here we go again. Presumption of the validity supports on the other hand, okay, so we have, once it's proven a marriage exists, the law presumes a marriage is valid and lawful and continues without termination. The presumption of the validity of the marriage, on the other hand, supports the inference that the second marriage was valid and that the first marriage therefore ended. So that's our presumed fact. Sorry. The first marriage ended prior to the second marriage is a presumed fact, but you need to first prove that the second marriage is valid as a basic fact. When confronting this inconsistency, the law generally gives the latter presumption. Okay. Precedence, presuming the validity of the second marriage. Gotcha. So the basic fact has some advantage here in the presumption, right? But nevertheless, it needs to be proven as a basic fact for the presumption to be invoked. All right. I have some footnotes here just referring us to other discussions in AmJur and a lot of case citations. We're on to section 219, subsequent common law marriage. Oh boy. Cupidity never ends. Let's see here on the chat. And looks like we're all caught up here. Pretty thin crowd, but it is Sunday, so I can understand. Let's continue. Courts also generally apply the presumption of the validity of a subsequent marriage to a subsequent common law marriage. The presumption's application raises no serious difficulty if the spouse from the first marriage had not been heard from for more than 7 years prior to the second marriage. Jeez. Because this is consistent with the presumption that a person who has been neither seen nor heard from for 7 years is dead. Even without a 7-year period, courts have been willing to accept a presumption that the first marriage ended in death or divorce in order to recognize a subsequent common law marriage. A few cases have been unwilling to recognize as a common law marriage in a relationship that began as a cohabitation during the existence of the first marriage. Wow, I've been unwilling to recognize that common law marriage. Presumptions that one who is absent from his accustomed place of abode and unheard from for 7 years was dead, and in absence of proof to the contrary, that death occurred at the end of the 7-year period, operated in favor of the validity of a subsequent common law marriage. Here's death. Section 551 for a discussion of the presumption of death after 7 years. It's a 7 years thing. All right, we're on to section 220, equitable considerations affecting standing to raise the presumption. The presumption that a second marriage is valid does not run in favor of a spouse who has been shown to have a prior undissolved marriage, unless that spouse can show good faith in contracting the second marriage. The spouse of the second marriage, however, would be entitled to rely on the presumption of validity without proof of his or her own good faith, where it was her deceased spouse who had a prior undissolved marriage. Oh gosh. The presumption is particularly strong when there are children of the second marriage or when an undeserving party seeks an equitable advantage. So this is an interesting case here. A spouse of the second marriage, however, would be entitled to rely on the presumption of validity without proof of his or her own good faith, where it was her deceased spouse who had a prior undissolved marriage. So just, wow, well, at least you got the presumption of validity. Courts have refused to allow a party to the second marriage to use the presumption to deny the continued validity of his own first marriage. This refusal is based on 2 considerations. The party's presumed access to direct proof and judicial unwillingness to allow the party to use the presumption to gain an unfair advantage. All right, let me take a break here for 1 second. Into the chat. We have power inherent in the people. Welcome and greetings. He's been putting on some great stuff lately. Throw his thing into the chat here. If y'all hold on 1 moment, because you need to subscribe to his channel. He has some great stuff that also expounds on some of the things we've covered here on this channel. So it'd behoove this audience to also check out his channel. Give me just a moment as I pull up the link here so I can post it in the chat for everyone. And that's power inherent in the people. And there he is, and here it comes. It's on its way. Come on. There we go. Bam. Okay. That's there. I need to refresh my chat because I don't even see it. It should be there. All right, there it is. Yes, indeed. Has some great interview there that I think was a part 4 coming up, but it's hard to not watch. It's such great, great content, great interaction, and tons of knowledge there. Of course, a lot of subject matter we've covered right here on this channel, so it's good seeing where the rubber meets the road and where we can learn so much from others' experience when we're applying this knowledge. So salute to you, power inherent in the people. Let's continue here. Courts have also refused to permit use of the presumption in situations in which the party seeking to invoke it had unclean hands. Ooh, is the big one here. Or sought to use it unfairly. Or where equitable considerations favored the surviving spouse of the first marriage. Several courts have also made it particularly difficult for strangers to the marriage to invoke the presumption to deny death benefits or similar benefits to the surviving spouse. Well, that's good. A claim by heirs of the second husband of a twice married woman to real property that had been owned by the woman and her second husband as tenants by entirety, based on successive deaths of woman and second husband, was properly upheld as against the woman's collateral heirs, based upon the presumption of validity of the woman's second marriage, where no evidence was produced to show the lack of divorce dissolving the woman's first marriage, or that the second husband contracted the marriage in absence of honest and reasonable belief that such marriage was valid, and no legal impediment to it existed. See, have been known. I hate these briefs the way they're written here because you got to understand it's written in the context of just that case, so the pronouns and stuff get a little confusing sometimes. Let's see this one here. Defendant was equitably estopped from attacking validity of prior divorce in light of the fact that he and his second wife cohabited for 16 years, had 4 children together, had, throughout the marriage, filed joint income tax returns together, had acquired several parcels of realty as tenants by entirety, and the defendant judicially admitted, in original answer filed in divorce action, that the second marriage was lawful. Attacking the validity of prior divorce. Okay, so it upheld. Interesting one there. Then we have succession of city versus succession of manual, holding that the presumption of validity of a second marriage does not run in favor of a spouse who had been shown to have a prior undissolved marriage, unless that spouse can show in good faith in contracting a second marriage. Here we are. Remember, marriage is a contract. The presumption is not available to one who deserted or abandoned the spouse of a prior marriage in another state and subsequently in this state remarried in bad faith and without reason to believe that the first marriage had been dissolved by death, divorce, or annulment. Wow. Interesting one there about desert desertment, and abandonment. Alleged husband was held to have no interest in the estate property of deceased wife, who had left all her property to her children, where their ceremonial marriage was void by reason of a prior undissolved common law marriage, wow, between the alleged husband and a woman whose previous husband had been absent for 22 years prior to the alleged husband's common law marriage. Wow. And that is in Texas. Let's see here. A presumption in favor of the validity of a descendant's latest marriage was rebutted where A. No record of divorce was found in two locations most likely for a divorce to have been procured. B. The wife and daughter of the first marriage testified that there was no divorce. And C. Equitable considerations did not weigh as heavily in favor of the second marriage, which was of short duration and yielded no children. Wow, that's three good tests there. No record, testimony, and you have no equitable considerations. Boy. So we're on section 221, the strength and effect of presumption. Yeah, thank you, power inherent in the people. Keep it running. Unclean hands. We have an unclean hands doctrine. We could take a digression into that, Bill Thomas. Let's do that. I think everyone wants to know, because we're all talking about presumptions here. Most of what we're seeing happening, I'll just say this as an aside, in the courts is presumption. Everything begins with presumptions, and the problem is that if these are left unrebutted, they become not just factual but mandatory facts, meaning that the courts have to acknowledge the presumed fact now as being worthy of evidence almost. So it functions as a tool of evidence, but very strong tool of evidence, shifting burdens of proof, burdens of production from one party to the other. So the presumption is everything really when it comes down to the process of litigating these situations. So here's where the knowledge of seeing where these pieces fit into the whole process of getting running from the presumed fact to getting it entered in as something that shifts burdens. So let's continue back to what we're looking here for the unclean hands doctrine. I hope it's here in blacks because we're going to have to go to the U's. It's going to be way down here. Oh, no, we're in the abbreviations. Got there pretty quick, though. Rule of inconvenience. And let's see if we can get to that unclean hands doctrine and just the general terminology of that phrase. Come on. Again, bear with me. This is a scanned document here. And we're pretty close now. We should be able to find it quick now. Forcible, undue, very close. All right. Unclean hands. Oh, great. Clean hands doctrine. So we're back to the C's. Hey, what do you know? We get there pretty quick. Come on, boy, a lot of those. Oh, we gotta move a little faster than that. A lot of conditions. Oh boy. All right. Didn't really realize how many CO words there were in law. All right, there we go. Clean house, slang, to discharge a considerable number of employees, usually in management. So that the new employees may be brought in. Or 2, to sell securities not meeting an investor's requirements. Clean house. All right, so we are looking for the clean hands doctrine, or yeah, clean house. Clean hands doctrine, 1914. The principle that a party cannot seek equitable relief or assert an equitable defense if the party has violated an equitable principle, such as good faith. Such a party is described as having unclean hands. For example, Section 8 of the Uniform Child Custody Jurisdiction Act contains an unclean hands provision that forbids a court from exercising jurisdiction in a child custody suit in certain situations, as when one party has wrongfully removed a child from another state, has improperly retained custody of a child after visitation, or has wrongfully removed a child from the person with custody. Wow, that's terrible. The clean hands doctrine evolved from the discretionary nature of equitable relief in English courts of equity, such as Chancery, also termed unclean hands doctrine. All right, I hope that cleared it up for everyone there. So we see it's a rather current term, 1914, and it has its roots in English Chancery. And again, I think the main part here is that he who seeks equity has to come with clean hands kind of maxim in operation here. All right, let's get back to the topic. And before we do that, let's double check here with the chat. Definitely, Bill. Pleasure to do it. Gonna drop on the blacks we have to. Yes, sir. Puff, puff, pass. Indeed. Yeah, we heard the phrase before, but it is a legal term, 1914, so it is rather current, especially considering, common law. But this was from courts of equity, its origins. All right. There we go. The presumption that a second marriage is valid, that is, that a previous marriage of a spouse terminated by death or divorce prior to the second marriage, is a particularly strong one. Although a few cases state that the party seeking to invalidate the second marriage need only do so by a preponderance of evidence, most courts insist the challenging party must disprove every reasonable possibility that the second marriage is valid, or establish the validity of the first marriage at the time the second by clear and convincing or even stronger proof. Jurisdictions that follow Federal Rule 301 direct that presumptions shift only the burden of production, not the burden of persuasion, unless otherwise provided by statute, affording the presumption less weight than had been given prior to the adoption of the rule. We were going over Federal Rule 301 before. So jurisdictions that follow the federal rule direct that presumption shift only the burden of production, not the burden of persuasion. So again, the basic facts will have to be produced by the party direct with the presumption. So yeah, not as strong as what we're seeing here as far as the other cases. So which courts is that referring to? Let's see here. 91 and 92. Okay, 92, Hewitt versus Firestone. When the party challenging the strong presumption that the marriage lasts in time is valid. So I guess like the second or the most recent marriage, introduces evidence which will afford reasonable grounds to presume the former marriage was not dissolved. The burden of proof shifts to the other party. Wow. Strong presumption. Party challenging the strong presumption that the marriage lasts in time is valid introduces evidence which will afford reasonable grounds to presume the former marriage was not dissolved. The burden of proof now shifts to the other party. Wow. Once the first wife presents evidence that her marriage was not dissolved, the burden of persuasion shifts to the second wife to show the first marriage was dissolved. Oh boy. The burden is on the party asserting validity of the second marriage to go forward with evidence to show that the first marriage was dissolved by divorce. So these are all the cases saying, with rulings in this manner, that can be briefed. So we're on to section 222, rebutting presumption. Let's bounce over here to the chat real quick and see if we're up to date. Need to refresh this sometimes, it gets stalled. All right, and I think we're on to the next section here, rebutting presumption. To rebut the presumption of validity of a second marriage, a litigant must show first that at least one party to the second marriage had been married previously. Okay, you have to show first. Second, that the prior marriage was itself valid. And third, that the prior marriage had not terminated by annulment, divorce, or the death of the other spouse. Where a party to a first marriage contracts a second marriage, but then resumes living with the first spouse, courts usually conclude that the presumption has been rebutted. That is, the first marriage never terminated, and the second, therefore, is invalid. Testimony by the spurned or abandoned spouse about the first marriage that he or she never filed for divorce and never received divorce papers may or may not suffice. Oh, geez. So 95 and 96. This one's in New York. Both are in New York. Writ of error. Interesting. The burden of proving that no court record exists of the termination of the first marriage by divorce or annulment depends on whether there was an adequate search in the jurisdictions of the prior residences of the spouses. Failure to pursue a divorce action to finality is also a factor. That's footnote 98. Let's see. Presumption of the validity of the second marriage was rebutted by evidence that a divorce decree had not become final until more than 1 year after the second marriage. So yeah, that second marriage was not valid. It was rebutted. And we have a nice little footnote up here. Let's read this one up. Record searches in every jurisdiction in which descendant spouse would have been likely to seek a divorce had turned up no evidence of such divorce. An affidavit showed a lack of any record of divorce in any of 4 counties in 2 states in which descendant and her first husband had lived. Presumption was not overcome by proof that no record of divorce could be found in Florida, where the parties to the former marriage had also resided in Georgia, and no evidence was introduced that a divorce had not been obtained in Georgia. Prior spouse must show where each party to the prior marriage resided up to the time of the second marriage and obtain a certificate from court in each appropriate county. Okay, so we can see due diligence in seeing if there is a divorce on record. Evidence the first wife never instituted divorce proceedings and was never served with divorce papers from her husband successfully rebutted the presumption that her husband's second marriage was valid. All right. This takes us on to section 3 or part 3 of relationship between spouses. And we're over on the hour, almost hour and a half mark here, or over an hour mark. So I think this is a good place to leave off for the next one. And we can see a little sneak peek of what we're going to be going over. The first part's going to be over property ownership. But it gets nice and juicy after that because, we're talking about relationship between spouses here. And for any of this stuff to end up in American jurisprudence, there had been some rather wealthy litigants here involving large amounts of fiduciary controversy. So it should make for an interesting topic and interesting situations, at least within the reading of the cases that they cite. So with that said, let's jump back over here to the chat and make sure we're up to date with everyone here. Great. I'm glad you enjoyed it. Power inherent in the people. This is definitely a little more chill than most of the conversations out there, but indeed it is an essential part to get to the foundations of this knowledge and have it in our toolbox and continually sharpen it by following up with the actions like you cover on your channel. So salute to you and salute to everyone that's out here standing up for being American. And before we go, we have to get back over and pay homage to the great Eon that brought us knowledge of this latest document here. And let me jump over to that. And there we go. Indeed, this is the Joint Resolution Public Law from May 3rd, 1940. And this is something that could be judicially noticed in a case if you ever have to show that perhaps sovereign immunity might apply to you in a non-core jurisdiction case that's being alleged. But this was a joint resolution authorizing the President of the United States of America to proclaim, "I am an American," Citizenship Day for the recognition, observance, and commemoration of American citizenship. Let's read the preamble here for this joint resolution, which is it is a statute at large. Whereas some 2 million young men and women in the United States each year reach the age of 21 years, and where it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. Therefore, be it resolved by the Senate and House of Representatives of the United States of America in Congress assembled that the third Sunday in May each year be and hereby is set aside as Citizenship Day, and that the President of the United States is hereby authorized and requested to issue annually a proclamation setting aside that day as a public occasion for the recognition of all who, by coming of age or naturalization, have attained the status of citizenship. That's sovereign citizens of our nation. And the day shall be designated as I Am an American Day. That the civil and educational authorities of states, counties, cities, and towns be, and they are hereby urged to make plans for the proper observance of this day, and for the full instruction of future citizens in their responsibilities and opportunities as citizens of the United States and of the states and localities in which they reside. So I think what we're seeing here is not just American citizens, but citizens of the United States, citizens of the states, localities, as the people being self-governing may have to operate in different capacities at different times, and having full instruction of those responsibilities and opportunities as citizens, right? That there's educational authorities are urged, right, for the full instruction. Nothing herein shall be construed as changing or attempting to change the time or mode of the many altogether commendable observations of similar nature now being held from time to time or periodically, but to the contrary. Such practices are hereby praised and encouraged, either at the time of the rendition of the decree of naturalization or at other such time as the judge may fix. The judge or someone designated by him shall address the newly naturalized citizen upon the form and genius of our government and the privileges and responsibilities of citizenship. It being the intent and purpose of this section to enlist the aid of the judiciary, your courts here, in cooperation with the civil and educational authorities and patriotic organizations, in a continuous effort to dignify and emphasize the significance of citizenship, approved May 3rd, 1940. Powerful stuff, something we all need to know. All right, just checking up with the chat here. Good thing you got the notifications, power inherent in the people. Glad to see that. We all need a shout out to Eon. If you're not familiar, you need to be. It's where we all hear about this stuff first. Indeed, the self-governing republic. So it was written, let it be done. There was a couple in there. There's different capacities, but as it states in here, just really quick to get back over to what they're stating here. The sovereign citizens of our nation, right? So this is the I am an American Day, not I'm a United States, but it's the President of the United States proclamation setting aside the day, the status of citizenship. I am an American Day. So there is American citizenship, there is U.S. citizenship, etc. So as is being said here, why else would they say the responsibilities of citizenship, right? And also where they're listing the different kinds of citizenship here also. The opportunities as citizens of the United States and of the states and of the localities. This is different capacities that when you're fully instructed, that the citizens, the American citizens, the sovereign citizens will find opportunities to take on these responsibilities in different capacities to keep the dream of a self-governing republic alive. And I believe that's what this is intended to say here. And I hope that's what people will get. Yes, audit them, indeed. This is truly the power to the people. As it said, the importance and the significance of the sovereign citizenship, the sovereign American citizens, as they state here. That's the language, not mine. That's their language. They say right here, so it is desirable that the sovereign citizens of our nation be prepared and impressed with their status in our self-governing republic. And more important, that we're supposed to be enlisting the aid of the judiciary in cooperation with civil, educational, and patriotic organizations to dignify and emphasize the significance of sovereign American citizens. Remember, this is still in effect. It has never been repealed. So take note. Once again, here's all the information you need to look it up yourself. You don't have to believe me. This is authenticated by the U.S. government, GPO, if that's any consolation. But there you go. Is what you look for is 54 Stat 178 in Chapter 183. All right. Well, who's our country except for the sovereign citizens of this nation? Sovereign American citizens. So anytime that they try to say something like, well, sovereign citizen is a oxymoron, or it doesn't make sense, or it's contradictory, remember, perhaps it is as you're reading it as a phrase. But as you see, because of this public act, it is actually now legal terminology. And it can be evidenced by this document here, which is law. This is a statute at large, which is the governing work for all these acts here. Everything has to be derived from that, because that was the one drawn by our legislatures and enacted. Therefore, the term sovereign citizens as words in a phrase in the vernacular perhaps is an oxymoron or a nonsensical term, or it might apply to something else. But in a legal context, it's very clear. It's terminology with a very clear definition. And that definition is right here in this joint resolution. So it's rather easy to have this noticed in any kind of case if it was needed to get that point across. All patriotic organizations are supposed to be in cooperation with the judiciary. This is what it's saying. But as you can see, especially on this date here, January 6th, we see where that cooperation has been non-existent or vestigial at best. And it's up to us to reinvoke this spirit of America that has brought us to this point of the experiment where it's up to this generation to carry the torch. Whether we do it or not, that's the choice we have to make. And whether it's worth it or not, it's going to be up to the people to decide whether they want to take that course or take us back into the dark ages again. But let's hope that we're getting the word out there. People are starting to see the empowerment of seeing this legacy in the true American mythology that we can all benefit from, not just for ourselves, but for posterity and to keep the dream alive. That said, thank you all for coming, and we'll see you all on the next one. Peace out.